The return of Donald Trump to the White House has ushered in a new wave of changes to the United States immigration system. Trump, known for his hardline stance on immigration during his previous presidency, wasted no time in implementing sweeping policy shifts aimed at restricting both legal and illegal immigration. From altering access to sensitive locations to challenging birthright citizenship, these changes have profound implications for immigrants, citizens, and the fabric of American society. This essay delves into the key immigration rules introduced or modified by the Trump administration, exploring their potential impact on various stakeholders. This examination of the new immigration landscape will provide clarity on the administration's approach and highlight the ongoing legal battles surrounding these controversial measures. As the nation grapples with the long-term consequences of these policies, understanding the nuances of these changes is paramount for informed civic engagement. The essay will further explore the potential implications for different groups, including immigrants and citizens, shedding light on the evolving dynamics of immigration in the United States. One of the most significant changes to immigration enforcement involves new federal rules granting Immigration and Customs Enforcement, or ICE, and Customs and Border Protection, known as CBP, broader access to sensitive locations. These locations, traditionally considered protected spaces, include schools, churches, and hospitals. The Department of Homeland Security argues that this expanded access is necessary to prevent criminals from evading arrest and to ensure the effective enforcement of immigration laws. However, this policy shift has sparked widespread concern among advocacy groups who fear it will create a climate of fear and distrust, particularly within immigrant communities. Critics argue that the presence of ICE and CBP agents in sensitive locations will deter individuals from seeking essential services, such as healthcare and education, out of fear of being detained or deported. Advocacy groups are urging immigrants to know their rights and to have plans in place in case of encounters with immigration enforcement. In a move that sent shockwaves through the nation, President Trump issued an executive order aimed at ending birthright citizenship for children born in the United States to non-citizen parents. This long-standing principle, enshrined in the 14th Amendment to the Constitution, guarantees citizenship to anyone born on U.S. soil, regardless of their parents' immigration status. The executive order argues that birthright citizenship has been misinterpreted and that it was never intended to apply to the children of undocumented immigrants. The executive order faced immediate legal challenges, with critics denouncing it as unconstitutional and a blatant attempt to circumvent the 14th Amendment. A federal judge temporarily blocked the order, ruling that it contradicted the plain language of the Constitution. Despite the setback, the Trump administration remains committed to challenging birthright citizenship, setting the stage for a protracted legal battle with far-reaching implications for the future of citizenship in America. Lawsuits from 22 states are currently underway, adding fuel to the fire of this contentious debate. Section 4, Executive Orders, a flurry of changes on day one. President Trump's return to the White House was marked by a flurry of executive orders, many of which directly targeted the nation's immigration system. These orders, signed on his first day back in office, signaled a return to his administration's previous hardline approach to immigration enforcement. Key among these orders were directives to strengthen border security, increase deportations, and limit access to asylum. One executive order called for the hiring of thousands of additional Border Patrol agents and the construction of new physical barriers along the U.S.-Mexico border, a continuation of his previous administration's efforts to fortify the border. Another order directed federal agencies to prioritize the deportation of undocumented immigrants with criminal convictions, expanding the pool of individuals subject to removal. These executive orders, while facing legal challenges from various advocacy groups, represent a significant shift in immigration policy, potentially leading to a surge in deportations and increased scrutiny of asylum seekers. Section 5. A shift in health policy. The removal of the COVID-19 vaccine requirement for green card applicants. In a move that reflects the evolving understanding of the COVID-19 pandemic, the United States Citizenship and Immigration Services, or USCIS, removed the requirement for green card applicants to be vaccinated against COVID-19. This decision, announced in January 2024, signaled a shift in the Biden administration's approach to public health and immigration. While the COVID-19 vaccine requirement has been lifted, it's crucial to note that applicants for lawful permanent residency in the United States are still required to undergo a medical examination and provide proof of vaccination against other communicable diseases as part of the immigration process. This policy change highlights the Biden administration's commitment to balancing public health concerns with the need to facilitate legal immigration and reunite families. Section 6. Navigating the Path to Permanent Residency. Updates to the EB-2 National Interest Waiver. The EB-2 National Interest Waiver is a complex immigration pathway that allows individuals with exceptional ability and whose work would greatly benefit the United States to obtain a green card without a job offer or labor certification. In January 2024, USCIS issued updated guidance for the EB-2 National Interest Waiver, aiming to clarify the criteria for demonstrating exceptional ability and its connection to the applicant's proposed endeavor. The updated guidance emphasizes the need for applicants to demonstrate that their work is in the national interest of the United States, going beyond what is simply beneficial to the economy. It also clarifies the definition of profession and specialty, providing greater clarity for applicants in these fields. These updates aim to ensure that the EB-2 National Interest Waiver continues to attract top talent from around the world, fostering innovation and economic growth while maintaining a rigorous standard for exceptional ability.